Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello and welcome once again to Ask a Lawyer here on CP24. Good to have you along for the half hour. If that's how long you're going to be sticking around for, I can guarantee this much: you're going to learn a lot about employment law. It's huge. Workplace rights. That's what this whole show is about. My name is John Scholes. Joining me shortly, my co-host and employment lawyer, Lior Samfiru from EmploymentLawyer.ca. I'll tell you right away and throughout the show how to contact Lior if you want to discuss a matter on your own. That phone number, 1-855-821-5900, ask at EmploymentLawyer.ca. And you can always go to the website, pocketemploymentlawyer.ca. We'll dip into that one in just a little bit. A hugely important show tonight. Why? The main topic in just a bit will be what to do when you are let go. That's like Employment Law 101. That's coming up, and we'll get to some phone calls from our long-running radio show, which you can join us Sundays at 1 p.m. on our sister station, News Talk 1010. But all that's coming up here in just a bit. Lior, welcome to the show. Good to see you again, pal. The week that was is always how we start. What do you got going on this week?
Hey, Johnny, I am so pumped to be here to talk about employment law and to try to help all our good viewers with this very, very important topic. You may not know your rights, but by watching the show, by listening to what we have to say, you'll learn so much. You'll learn about what your rights are if your boss is doing something they're not supposed to, if you're given an ultimatum, if your job changes, if your job no longer exists, temporary layoffs. I can go on. I think you get the idea. If it touches on the job, on your workplace, on employment law, this is the time, this is the place where you learn so much. You arm yourself. That's really what it is. You're armed now with this knowledge, with this information that you can use to make sure that no one takes advantage of you. We have good laws, but the laws can't do anything for you unless you understand what they are, unless you give them that opportunity. So you're in good hands right now. And of course, beyond the 30 minutes of the show, you can reach out to me and my team across Ontario to have that discussion, to make sure that you understand your rights and that we roll up our sleeves to get to helping you enforce those rights. But let me start off with the situation that came across my desk. I spoke today with two gentlemen who contacted me together. Well, they have been working for the same employer, one for about 25 years, the other one for about 18 years. And they were by far the oldest people in this small company. They've been there a long time, but they're also now in their mid or late 60s. Everyone else, they're much, much younger than them. Well, very recently, they were called separately into meetings and were told, you guys are being let go because of restructuring. Now, a company of 71, 72 employees, these are the only two people that were let go. And again, they've been there the longest, no performance issues. So what they said to me individually is, well, we actually think that this may have been because of our age. We can't understand another reason. There's no obvious restructuring going on. We're the only ones being let go. Companies otherwise doing well. We think that this is influenced by our age and we're not okay with it. So of course they're not okay with it because it's completely illegal. You cannot be let go because of your age. Let's make sure we remind everyone that we got rid of mandatory retirement in Ontario almost 20 years ago. So you can work till whatever age you want, 65, 75, whatever that age is, and your employer can't do anything about it. If your employer does anything to you because of your age, that's a human rights violation. Even if your employer lets you go for several reasons, but one of those reasons is your age or has anything to do with your age, that's illegal as well. And based on all the facts that these gentlemen gave me, it became very, very clear that this is what's happening here. The only two people being let go, older individuals, it's clear to me that this is age discrimination. So beyond just the severance, by the way, they're both owed about 20 to 24 months of severance. They were offered much less. But beyond that, there's possibly human rights damages as well. If you're let go because of your age, because of your gender, because of your race, your religion, disability, That's illegal, irrespective of severance. If your employer does anything like that to you, you have to call me, because this is where the law steps up and make sure it says, no, that can't be.
Lior, just quickly, can this be a tough thing to prove? I mean, the average employer is not going to go, yeah, of course, we're letting you go because you're age. Get out, you're ancient. It's not going to happen, right?
Yeah, in many cases, we suspect it may have something to do with the age, but we really don't know for sure. How do we show what's in someone's mind? But in some cases, like this one that I just told you, the facts are so clear that it's really difficult to see anything else. Again, this case, the only two people were the two people that were oldest in the company, by far older than anyone else. No one else being let go. So it's tough for the company to say, oh, it's completely unrelated to age. But you're right. The employee always has to establish and prove if they're alleging that the company did something wrong.
All right, good stuff. Again, reminder, Sundays, 1 p.m. News Talk 1010. Lior and I do our radio show. You can call in anytime and ask your questions. We'll get to our first call from the radio show right now. Listen up.
Worked for a company for 25 years. They let me go. They said it was performance. I was going through some stuff at home, and they gave me an offer of a settlement, $5,000. They made me sign it, or else they wouldn't give me any money. They used the term just cause. They had just cause to let me go. I'm 56, and It's a trucking job.
I'm going to take a deep breath before I answer this, John, because this is so wrong on so many levels. Remember what I've always said. Once you sign off on that severance offer, whatever that is, however bad it may be, generally you can't go back, you can't get out of it. Now, that's a huge problem for this person, because after 25 years, he was offered a meager, measly $5,000, or much more, but he signed that release document. And I understand the pressure, of course. You feel the pressure to sign. You feel like you have to. You feel like you have no choice. I'm telling you, you have a choice. You shouldn't sign. The company can't do anything to you, and your legal rights don't expire on that deadline. Do the right thing and make sure we get everything you're owed. So to emphasize this point, we know that this person accepted $5,000. Let's see how much this person actually would have been owed in severance. To do that, I'm going to go to my favorite tool, which is the severance calculator. You can find that at PocketEmploymentLawyer.ca. It's free and anonymous, but let's see what this person should have received. So 56 years of age, as a truck driver, been there for 25 years, it's a long time, was offered $5,000 and accepted it, except he was owed about 18 to 24 months pay. At that salary level, John, that's anywhere from $77,000 to $95,000. So he potentially accepted $90,000 less than what he was owed. Don't let that mistake happen to you. Don't ever do that. If you are let go, whether you work for 25 years like this person or 2.5 months, you call me before you sign anything.
And that, Lior, dovetails nicely into our main topic for the show, which we're going to get to on the other side of the break. What to do when you've been let go. Do not turn off your TV right now. Watch and stay tuned for this. It's on the way next year on Ask a Lawyer.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, and welcome back to Ask a Lawyer here on CP24. Want to remind you can reach out anytime to Lior Samfiru, Employment Lawyer. Use the phone number. How about that? 1-855-821-5900. The email is ask@employmentlawyer.ca, or use that QR code on the right side. That's just as good as well. As I mentioned before the break, Lior, massive topic today, what to do when you've been let go. We're going to go through 3 or 4 talking points, and these are all really important. I know you'll want to break them down. Number 1, always don't panic. Document everything, right?
You know, I know it sounds perhaps patronizing to say don't panic, but the reason I'm saying that is because people often make bad decisions when they're let go, and it's because they feel that sense of panic, that pressure, that stress. And you know, no one, myself included, we don't make good decisions. We're in that state of mind. So you have to always think rationally, calm down, understand that this has happened. You can't undo the termination. Now it's time to make some decisions and make sure that we enforce our rights and make sure that we're prepared to move on in a healthy way. So that may mean write down anything you need to write down. If something was said to you during the conversation with your employer during the termination, get copies of your employment agreement. Make sure you have the termination letter. Make sure there's a bonus plan document, get a copy. Let's have those documents available to us. We may have to analyze them later on. But the key point is this. I know it's hard. No one ever expects to be let go, and oftentimes it can be very traumatic. But despite this, we have to think calm. We have to think rationally, just like when we would in any other important time in our life. And if you do that, the right decision is going to flow from there.
Second thing you need to do, Lior, as mentioned earlier in the phone call that we had, is do not sign anything. Do not put pen to paper.
That is so important. So we talked about that difficult state of mind you may be in when you're let go. Well, guess what? You're in that state of mind. Your employer offers you money, that severance offer, but they put a deadline on it. You better sign this by Friday. Well, you absolutely must fight that urge or that pressure to sign that severance offer by that deadline, because your rights don't expire on that deadline. You have the right to take the time that you need to review it, to understand it, and get legal advice. That deadline is a pressure tactic. That's all that it is. And your employer is hoping that you'll accept the bad offer because of that pressure tactic. Please, please, please don't let that happen. Every week, I speak with individuals that accepted terrible severance offers because they felt that pressure. They felt they had to. And then they realized they're owed another $75,000. Now they can't do anything about it. No matter what, do not sign anything. Let's talk. Let's make sure you get what you're owed. Once you sign it, it's almost impossible to get out of it.
Talking about what to do when you get let go, first few steps you want to make. Number 3, Lior, is this one. Apply for EI. That's fine. You want to do that. But do not go to the ministry for severance. Do not.
So certainly you should apply for EI, whether you're getting severance, you're not, whatever it is, apply for EI. Make sure that you preserve those rights, okay? EI may not actually kick in for a while, but you should always apply as soon as you can. Now, in terms of the government, when it comes to your severance package, your entitlements that you're owed upon termination, you cannot go to the government for severance. The government cannot help you get your full entitlements. The government can only help you get a small fraction of your entitlements, and by going to the government, you're then prevented from trying to pursue your full entitlements. Please, please, please don't do that ever, ever, ever. Again, talk about things that I do often. Often I speak with individuals that have done just that have gone to the Ministry of Labor, got 2 weeks pay when they were owed 10 months pay, and now they want my help, and I have to tell them, I can't help you because you went down the wrong path. When it comes to losing your job, do not go to the Ministry of Labor. Let's talk. Let's make sure you get your full rights and you're not giving up any of that.
Okay, Lior, the fourth and final one for the show tonight, things to do when you're let go from your job. If you haven't figured this out already at home watching the show, contact an employment lawyer. He's right there. Give him a call, right?
Now, listen, John, I'm an employment lawyer, so yeah, I get it. It sounds very self-serving when I say, call me if you lose your job, or call an employment lawyer. So let me put it a different way. Yes, I want you to call me. I want to help you. But if you don't like me for whatever reason, maybe you don't like my tie or my jacket, that's okay. Call another employment lawyer. But you have to do that, okay? You have to get legal advice because you only have one chance to do this right when it comes to your termination entitlement. So one chance to make sure that you get what you're owed. And oftentimes, if this is done right, your severance can get paid and resolved very quickly. It's not something you have to live with for months or years, not at all. Oftentimes we can resolve that within days or weeks. So please do the right thing. I know it's stressful. I know you're under a lot of pressure. Please call. Let's make sure you get what you're owed.
All right, good stuff, pal. Let's move on again. A reminder, weekly radio shows. News Talk 1010, Sundays at 1 p.m. Lior and I going back and forth with our callers. Here's the second phone call for this show right now. Listen up.
My wife walked away from the job recently. She was financial controller. And the reason being is constant harassment from the employer. And the final thing was that the employer sent her an email stating that her and another employee not allowed to talk in a native language. My wife works as an accountant, so she doesn't deal with customers. So she just didn't like this and just walked away from the job. Is there sort of recourse or anything that can be done about that at all?
Wow. What do you think, pal?
Certainly, if you're a victim of harassment and bullying in the workplace, that's illegal. You don't need to be a legal expert to know that can't be, that's illegal, and your employer has to protect you from that harassment. And if they don't, that could be a human rights violation. That could be a violation of several statutes. It can also be a constructive dismissal. Here, potentially, we also have a different human rights violation. Potentially, if this person was prevented from speaking their native tongue, and there's really no good reason for that, again, that could potentially be discriminatory. That could be a human rights violation. All of this could result in a constructive dismissal. What this means is if she left her job because of this harassment, this discrimination, the law doesn't say that, the law says that, wait a second, it's not really a resignation. It's a termination. It's a constructive dismissal. And she could still get her severance in the situation. And depending how long she's worked there, that could be a very substantial amount. Same with you at home. If you're in a workplace that's being treated, or you're being treated improperly in the workplace, a poison work environment, you're bullied, harassed, discriminated against, all of that is inappropriate. Other than getting that to stop, you may also have the ability to get out of that workplace with compensation, with severance. If any of this sounds familiar, or if you're ever in that situation, let's talk.
We have lots more to get through, including our third phone call, Lior, but we'll do that on the other side of the break. So stick around for that as we continue Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. This is CP24. As you know, John Scholes and Lior Samfiru weekly. We're giving you the information you need to know about employment law and workplace rights. The phone number anytime to reach Lior, just like this, 1-855-821-5900. Ask at EmploymentLawyer.ca. And our weekly radio show, News Talk 1010, our sister station, Sundays at 1 p.m. You're always invited to call in at that time for the hour, and maybe your phone call will make it here on this particular program. Lior, we'll get to phone call number 3 from the radio show right now.
I've been laid off. It was originally a temporary layoff for 13 weeks. Then after that, he gave me 35-week temporary layoff. Now that it ran out, he said, I can hire you back, but he doesn't have enough work to have me work every day full time. So he's just trying to get out of the termination pay that he owes me. Worked there for 13 years. Okay. Automotive technician.
So, John, first of all, that temporary layoff, that was also illegal right off the bat, whether it's the 13 weeks or the 35. So this person could have treated that layoff as a termination, as a constructive dismissal, and forced the company to pay severance. Well, he didn't do that, but now when he wants to come back to work, company says, we don't really have your job for you, we have much less hours. Well, that's another type of constructive dismissal. So he now is also in a position yet again to say, no, I'm not doing that, I'm not waiting, I'm not trying to work less hours. I'm going to force you to pay me my severance and consider this to be a termination. That's what a constructive dismissal is. So, of course, the question now becomes, how much severance is he owed? I'm going to go back to the severance calculator. Of course, you can find it at pocketemploymentlawyer.ca. So let me show you what this person is actually owed. 52 years of age, automotive technician, been there for 13 years. Company is trying to avoid paying severance. We know that. Except we see, because this is a constructive dismissal, he is owed as much as 16 months pay, 1/6. That's a significant amount of money. So same with you. If you're put on a temporary layoff, that may be a constructive dismissal. If your hours have changed, or your compensation, or if you've been demoted, all of that could be a constructive dismissal. That means, of course, you're owed your full severance.
I want to remind you can join Lior and his team weekly on their live stream on YouTube, Facebook, and LinkedIn as well. At stlawyers.ca is how you do that and chime in. For this week, Lior, I'm on my second medical leave in 3 years. The company accommodated me the first time. My long-term disability benefits have just been cut off, and I'll soon have to return to work, but my employer won't accommodate me this time. What are my rights?
There's a very strict and important obligation on an employer to provide accommodation if an employee has medical restrictions. Now, we know this company is able to accommodate because they've done it before. So they can't just decide, well, this time we just don't feel like it, it's too much of a pain, so we're not going to do it. They have to do it. If at all possible, the company must provide that accommodation. That failure to accommodate is a human rights violation. It's illegal. So get that doctor's note. Make sure that doctor's note says what kind of accommodation you need. If your employer won't, refuses, ignores it, you call me. We can either force your company to do that or get you out of there and get you the damages and compensation you're owed because of your employer's failure to accommodate.
Okay, Lior, we got time for one more email to wrap up the show. We'll do that on the other side of the break. More Ask a Lawyer is on the way. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer. Let's get to that final email for the show. Lior, it goes like this. I was fired for refusing to do unsafe work and reporting it to the Ministry of Labor. Can my employer do that?
How about no, no, and no again? Absolutely not. We have very strict rules and laws that make it so that you can refuse unsafe work. And your employer has to deal with that refusal. If they don't, you can contact the Ministry of Labor and they come in and investigate and they can order your employer to fix the safety issue. And what your employer is never allowed to do is they're never allowed to punish you in any way for refusing that unsafe work. We call that a reprisal. Can never happen. Safety first. I know it's cliche, but it's true. If your employer won't deal with safety, if they put you in an unsafe work environment, you can and should refuse. You must refuse, in fact, and your employer can't do anything. And if they do anything at all, Ministry of Labor is a good option to go to. You can call me as well, but always, always report unsafe work and refuse to work if you need to.
All right, thank you, sir. That 30 minutes goes rather quickly, but this is your opportunity to reach out to Lior now that we are done for this week. I'll give you the phone number first, 1-855-821-5900. Email always is ask@employmentlawyer.ca. The website that Lior used and talked about a couple times, pocketemploymentlawyer.ca. And for all other matters, cp24.com/ask-a-lawyer. That is all. We'll catch you next time next week right here on Ask a Lawyer on CP24.